So a lot of documents finally hit the Idaho Cases of Interest webpage today, because we knew these documents were out there because they were on the case summary log, but they just hadn't hit the portal to look at. And I was waiting to see what this one was about because I knew the prosecution had turned over their expert list on the 18th. So I was like, well, what is the defense claiming is missing? And so here's the motion to compel ICR 16b7 material and for sanctions. And Anne is stating that the bulk of the state's expert disclosures fail to include opinions and reports. Says these inadequate disclosures greatly prejudice Mr. Koberger. She's also saying the sanctions that she wants considered must be the exclusion of the experts, or at a bare minimum, an order compelling the missing information, and an extension of Mr. Koberger's January 23rd, 2025 deadline. And that's the deadline for the defense to turn in their expert witness list. And it says Mr. Koberger is prejudiced because he does not know what expert evidence the state intends to elicit. He does not know what expert evidence he must confront. And then under relevant facts, they state that on December 18th, 2024, the state disclosed 25 experts. Of those, only 5 include actual expert reports. Notably, not a single DNA expert opinion or report was produced. Instead, the state's disclosures refer to Bates-numbered pages and say, the disclosure is provided as an aid. It does not encompass all findings, impressions, conclusions, or materials related to this expert's involvement in this case. It further does not in any way limit the scope of the expert's testimony. Further, this expert may testify about findings, impressions, and/or conclusions that he or she drew from the work of other experts who previously examined or handled the evidence in question. At least 3 digital forensic experts are disclosed with lists of 67 electronic devices or third-party databases examined. Not a single report of what the 3 experts will opine is related to any specific device or data is disclosed. Now, I am curious what those 67 devices are. I'm very interested now to hear the full evidence at trial. Now, of note, at the bottom of the second page, there is the footnote, and it says, Mr. Koberger does not include here a motion to strike the death penalty for failure to properly disclose experts. Without proper disclosure, that motion is forthcoming. So basically, they're saying that if they don't turn all of the rest of this information about the experts over, then they will call for sanctions to remove the death penalty. And page 3 is more of the argument, and it talks about how the disclosure lists 25 experts and provides their CVs, but only 5 have expert opinion reports. So they're talking about the state law, and it's saying on written request of the defendant, the prosecutor must provide a written summary report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rules 702, 703, or 705 of Idaho Rules of Evidence. The summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications. Disclosure of expert opinions regarding mental health must also comply with the requirements of Idaho Code 18207. The prosecution is not required to produce any materials not subject to disclosure under subsection G of this rule. This subsection does not require disclosure of expert witnesses, their opinions, the facts and data for those opinions, or the witness's qualifications intended only to rebut evidence or theories that have not been disclosed under the rule prior to trial. So now I'm kind of wondering, is the prosecution thinking that they don't have to turn over these opinions until the defense turns over their witness list so that they can rebut? It's almost sounding like they're thinking these expert opinions will be for the rebuttal. So I'd like to hear what Bill Thompson's reply to this is going to be. And then they also state what the Court of Appeals has ruled. And it says the plain text of Rule 16b-7 requires the disclosure of expert witness opinions, the facts for the data for those opinions, and also any testimony that the state intends to introduce pursuant to Rules 702, 703, or 705 of the Idaho Rules of Evidence. This encompasses not only the expert's opinions, but also scientific, technical, or other specialized knowledge to which a qualified witness may testify in a form other than to an opinion. See IRE 702. And then it talks about State versus Morin. As the court explained in Morin, when an expert relies on some form of scientific or technical information, that must be disclosed, as opposed to other witnesses whose opinions may be of the less scientific variety. So it sounds like they're talking about some of the witnesses, possibly even the FBI witnesses, who may have technical knowledge, as opposed to kind of like a Brett Payne who just had vague understandings of those things. He would not be an expert witness as far as anything regarding the technology, the cell phones, drive testing, etc. The medical examiner would be a technical expert, for example. So it's just interesting. I'm really wanting to know who the ones are that they did not submit the full information on. And then page 4 is just saying that in that case, the state violates a disclosure requirement under ICR 16b-6. The trial court has considerable direction to fashion an appropriate remedy. State versus Montgomery. So Mr. Koberger continues wading through a sea of discovery. The need for rule-compliant expert disclosures is critical to his ability to prepare for his defense at trial. The state's failure to comply is not harmless. And then it says, in conclusion, Mr. Koberger must be able to confront the evidence against him, and to do that, it must be disclosed in accordance with Idaho Rule 16 and this court's trial setting order. The expert evidence disclosed by the state is woefully inadequate. This is a capital murder case, and compliance with the rules of discovery are not optional. Mr. Koberger is prejudiced by the state's failure. It is impossible for him to confront unknown expert opinions with his own expert disclosures by January 23rd, 2025. And then there is another footnote at the bottom of page 4. And that footnote says, recently in State v. Lori Vallow-Daybell, the Idaho court struck the death penalty when the state produced recorded jail calls after the court's imposed deadline. Failure to properly disclose experts is arguably more prejudicial than late disclosed jail calls. Now, I do also want to point out that part of why the death penalty was also struck was because the defense also made a persuasive argument that Daybell's mental situation should also be taken into consideration. So even though Idaho doesn't have an insanity defense, if you can prove that the person's mental situation is one where they shouldn't get the death penalty, the judge can use his discretion and also strike the death penalty. So you need to put that into the mix as well with the Daybell sanctions. Now, there was also the subpoena that showed up on the document page today, but it doesn't really tell us much. So here you can see the subpoena ducis tecum, and it does not have the person's name there. They whited it out, and it does not have anything down below about why they're being specified to be there, but it is for the January 23rd hearing. So that is the hearing where they're going to be listening to all of the motions to suppress. So it's somebody that the defense thinks is going to be helpful to them in getting some of those motions to suppress. So now I'm really curious, because I thought maybe it was another subpoena to the FBI. But if it's like the cast report, I don't really think they would need that to be brought to the hearings for the motions to suppress, because you'd think they'd want that cast report suppressed. So I don't think they would want to call the FBI as somebody on their side to do that. To me, you would think the prosecution would be calling the FBI to come there with that to prove why it shouldn't be suppressed. So I am curious now who this person is and what they are supposed to be producing on January 23rd. So, hopefully that hearing's going to be open and we'll get to find out lots of things, but I'm not going to hold my breath. And then also hitting the website today was the the defense's replies to all of the prosecution's objections to the motions to suppress. And the defense asked for a motion for leave to exceed a page limit. So they want permission to go over the page amount for one of their replies to the prosecution. And the state's response to the 20th supplemental request for discovery, but it didn't contain anything in it other than what all of their past ones have contained, which is just saying, see this date, see this date, see this date, see this date. And then, so we don't even know what that one's about. The defense cites an Exhibit T. That's all we know for now. And then also stipulated motion to file the defendant's replies to the state objections to the Franks and IGG under seal, which of course, anything with that IGG information in it, we know will be under seal because that went back under Judge's orders, and Judge Hippler has continued those from way back then. So, if there's any of those documents you would like me to go over in further detail, please let me know.